learned senior advocates, participants at this SLP webinar. It's my pleasure to welcome you all to this evening event. As you can see, there's a case scenario that we've put up. It promises to be an interesting engagement today. But before we proceed, I'd like to invite the section chair to formally welcome us as Mrs. Omalabi SAN, OON-SAN, to welcome us formally.
Thank you very much, very able moderator, and thank you so very much for all our very distinguished speakers. I have to be particular about one of them, Professor Juku SAN, who we all know as teacher. Teacher, you're most welcome. Our chief servant, Marcos Fernandez, he's been amazing within the Nba-Slp and also in the Office of the Attorney General. You're also most welcome. And Ms. Titiola, I really look forward to hearing from you. My task is very simple, and that's to welcome all of us, to thank the chair and the members of the committee for putting this very topical webinar together. And it is the first of this committee of the section for 2025. And I think it's just, very timely because, we recently had for those of us who are in the inner bar, a circular from Bosan. I've had numerous questions from practitioners wanting to know what is advertisement, what is allowed and what isn't allowed. And I know for a fact that we have well over 800 delegates already registered for this. And barring difficulties with network, we're going to have a very good showing. So without further ado, I just say welcome all. I'm here to listen and learn as much as everybody else. And I thank you for taking the time to give us this, to have this conversation, and thank those who are also attending. Most grateful. Thank you, moderator. Over to you.
Thank you so much, section chair, and for your able leadership as well. We're grateful. She's still on? Right.
Yes, I am. I'm going to participate. I'm here to listen and learn as much as everyone else. I'm here.
So as background, my name is Bayo Moli, legal practitioner for a bit above 2 decades, and a keen observer of the legal profession and someone who pretty much wants the best for the profession and for myself, because this is where I feed from. So this is what has spurred all of us in the think tank group in the SLP. And as you know, the SLP is like the think tank for the legal profession in terms of legal practice. And so recently, as the section chair just alluded to the circular that just went around from Bosan, and Bosan, of course, is the body of senior advocates of Nigeria, basically, was a cautionary note emphasizing the prohibition of advertisement and self-adulation and basically advertisements, adulatory publications, and, well, websites and social media statements that could actually, be interpreted as some sort of advertisement. And that got the legal profession, agog. And we thought in the SLP that we should bring it up, especially in the litigation committee. And so today, to deconstruct this topic with me today is I've got 3 people. a very erudite scholar who needs no introduction. He's called Teacher. He's a senior advocate of Nigeria, and he was very instrumental to the drafting of the extant rules of professional conduct. That's Professor Ernest Ojukwu, SAN. Also, we've got a teacher of law, a very distinguished teacher of law as well, who I would imagine is a child of the teacher, well, not biological child, of course, in the profession, but of course is very focused, particularly on professional ethics. And we thought it was important to hear the view of the law school. These are the people bringing the lawyers to, giving birth to lawyers, essentially. And we've got Dr. Titilola Hamid on the panel. And finally, got I call him the Fernist, someone who is an enthusiast, is a tech law enthusiast, and somehow National Duty has called him to serve as the special, as senior special assistant to the president or to the Attorney General. And he's just quite vast in tech law as it relates to, and he's going to be speaking today as it relates to advertisement and Rule 39. Now, the rules of professional conduct is wide, and that's what we follow in terms of ethical conduct. But we're focusing today, we're zeroing in on Rule 39 precisely. We're going to have it in the chat box. Of course, you also have ahead of you, right on the screen, there is a case scenario that we've put together that you can read that can help us situate some of these things and test our knowledge about what exactly we're onto, what exactly we're trying to achieve. Now, this is not going to be a very long session. We're hoping to wrap this up in an hour or just about over that. But we want a very engaging audience, engaging participation from you. And so we're going to have questions. Of course, you can start preparing your questions and answers as soon as the conversation start going. Also, at some point, you're going to have some polls that we're going to throw out so that we all are involved in this. So without further ado, Professor Ojukwu, let me start with you. Maybe, Professor Ojukwu, are you there now?
Yeah, sure, I'm here.
Great. So you were and I must thank you very much. You jumped right out of court to join us. So,
yep.
I mean, right out of a trial, actually, to join us. We're really grateful for that, for your time. As one who's contributed greatly to the, current version of the RPC, why do you think the restriction on advertisement was introduced, and what sort of behavior do you think would constitute an infraction of these rules? What would not? I mean, speaking in general terms, as like the author of the current rules, and why do you think this might still? Do you think that there's still possibility of looking at it again, considering that there's still some dissatisfaction in some quarters?
Yeah, sure, great. Thanks, Omole. I'm happy that you're standing on your two legs, because I know that you went down a bit on your health in the last 24 hours. So to see you still smiling, it's a great one. Now, what we did with the 2007 rules, which is now 2003 rules, was to improve on the provision on advertisement. We had the rule, so it's not a setback, it's an improvement, it's a change. Because before we made the 2007 rules, we had debates and we had programs in the bar, in the conferences, debating on if we should have advertisement or not. And majority of people said, yes, time for advertisement, but place some restrictions. Because every advert, whether it is for lawyers or not, it has restrictions everywhere in the world. You can't advertise everything. So general adverts in Nigeria are not permitted. You can't just go to the billboards and post anything you like. So the same way the professions, not only the law, also cherish some limitations on advertisement. So this current provision is an improvement of the 1975 rules of professional conduct. Rule 33 was very unclear as to what we should not do with advertisement. First, it starts by declaring, that's Rule 33 of 1975 rules, that it is contrary to professional etiquette for a lawyer to solicit professional employment by circulars, advertisement, etc. So, reading the first paragraph of Rule 33 of the 1975 rules, what it seemed to ban was only solicitation, not advertisement, through every means, including advertisement. But it went on to its second sentence to say indirect advertisement for professional employment, such as furnishing or inspiring newspaper comments or procuring a photograph, etc., was also wrong. So by that second provision, it was doubtful that they were referring to solicitation. It seems they were now referring to the general concept of advertisement as different from solicitation, because they're two different things. And so based on the history of the common law, where generally barristers were not allowed to advertise, it seems that the background to Rule 33 was a presumption that advertisement was not permitted. And therefore, in couching Rule 33, they specifically outlawed solicitation and outlawed indirect advertisements. And so by specifically outlawing indirect advertisement, it suggested that reading the whole, it meant no advertisement. And that was the regime up to 2007 when we enacted the new one. The new one now attempted to tackle it by first declaring that advertisement was right, and then created the restrictions or the exceptions to it, about 7 of them. Things the advertisement will not bear, will not contain, should not be the mode of it. That's just what Rule 39 provided. And it also banned solicitation in addition to those restrictions on advertisement. So this is the general background to Rule 39. So I don't know the other angle of the question you wanted me to answer, to refresh my mind so that I won't deviate too much.
Yes, I wanted you to sort of provide specifics as to, yes, I mean, like scenarios of what would. I mean, we're looking at people putting out publications talking about what they've done.
Yes.
The
Rule 39 says you shouldn't talk about the quality of your work. You shouldn't. That's one. It shouldn't compare with other people. That's another one. It shouldn't be frequent. It should be frequent. So frequency envisages where every day on the pages of this day, you are there page 7 every day. Its frequency also envisages you are on the radio. Every 30 minutes, there's a break and your law firm is announced. So those are the kind of things that it banned. It did not, and that was one of the problems that we found after we had enacted it. The mode where to advertise was not specified in Rule 39, and it was an error. The error was that Rule 39 had more elaborate provisions than what we have now. And there were lots of explanations and exceptions created under it to illustrate how to apply Rule 39. And they were quite elaborate and seemed to be a bit complex, but not quite complex. But because at the point of going to the Bar Council to approve it, the president of the bar, who was desirous then, and the secretary of the bar, very desirous in having new rules, Rabana Lawal, sat together over the draft and didn't feel that the other provisions were helpful, probably because they had not had a lot of time to look at it. They felt it was complex. So we had to chunk them out. In chunking them out, because we had short time to go to the council, we eliminated some of those things that would have been easier to identify. So that's one of the reasons, for example, solicitation is not defined. In that thing we chunked out, solicitation was defined. The modes, whether you should go to newspaper and so on, they were all defined in that thing that we mistakenly chunked out because we are limited by time. Those are the limitations. And we're tackling it now on a new draft we've done now.
Thank you, Prof. You did mention just now that there's on a new
yes,
draft.
Well, we've been working on a new draft since 2 years now. So
this seems very timely considering the issues that we're about to around, because from what Prof has said, there might be some sort of narrow. I'm wondering whether it's the narrow or broad interpretation you're giving to the word advertisement. Because clearly, I mean, advertisement could range from, showing up, to say this is what I do, to making newspaper or radio, pronouncements. And of course, in the US, we all know that there is really no limit to what advertisement. There's a whole whatever out there. People can go out and advertise that I'm the best lawyer around.
No. There's a limit. Yes, you can say you are the best lawyer in town. You have to have evidence. There's a limit in US. You cannot, whatever you say about yourself, that quality must be true. If it is not true, you are in for it. There's a limit. And that the same thing in the US has now also been allowed for the barristers in England. For solicitors, it's even wider. They're allowed to say they're the best. But in saying so, you have to put the evidence in that advertisement of that being best. For example, if, you said, I've been ranked as a leading lawyer in the field of money laundering, you must specify for us the person who announced you as the best. So, for example, if you say directory, you say in the directory of, or in the association of, you must announce it. Even in England now, the barristers rule permit you to say everything you want to say about your quality of your work, as long as you are not telling a lie, and you must disclose, for example, the source of that quality you are creating, you are detecting for yourself. So you can't just say, I'm the best. You have to say something about it.
Thank you, Prof. So moving on to, teaching this rule in school. Let me invite Dr. Hamid, right, to enlighten us on how effectively the law school educates students on the nuances of legal advertisement. Is it totally restrictive, or are there leeways by which they could push out themselves? Or why do many new lawyers struggle with understanding the boundaries? Or is it, should there be some ongoing ethics training beyond law school? Or what let's just understand, can you just throw some light on what goes on in the law school in terms of ethics training as regards this rule on advertisement solicitation in Rule 39?
Right. Good evening, everyone. Good evening, Prof. Good evening, sectional chair. Thank you, moderator. Let me say that I'm here as Dr. Hamid and not particularly a representative of the Nigerian Law School. So my views are what I am expressing, or what I'll be expressing. So in Nigerian Law School, we teach them professional ethics and skills as one of the 5 courses that they offer. And we teach them different regulations or legislations that pertain to ethics and skills, which include your RPC, your LPA, rules of accounting, and all what you have. So for for advertisement, the area where that comes up is under your RPC, particularly under Section 39. So Section 39(1) says that you're allowed to advertise for as long as it is fair and proper and in consonance with the provisions of the rules of professional conduct. But it goes on in sub 2 to tell you what you cannot do, how you must not advertise. So that's why it tells you that you must not mislead persons, it must be accurate, it must not be annoying, it must not be frequent, and all that. So when you're talking to the students, and they're listening to you, and you get to the part of that you cannot compare the size of your practice with any other, or you cannot attribute the success. It'll talk about the success of your law firm and stuff like that. they begin to, hold back and wonder that, okay, how do they go out there and show what they do? But the law is the law. It remains the law until it is changed. Today, it is Rule 39, 1 and 2 on advertisement. And then for soliciting, that one, they're not even allowed to do at all. So those are their concerns, when you talk about advertisement. Main concern being that, okay, by the time I finish reading law for so many years, 5 years at the university, 1 year in the law school, having to serve, how do I put my business out there for other people to know? So that's basically it.
Thank you very much. You've spoken about, in the chat box, there is Rule 39, and it will be very important for the participants to actually look at it. It's been shared in the chat box so they can zero in on actual rules. The provisions of Rule 39, and critically, look at them and see what they say. Rule 39, if you look at Rule 39, 2, D, and this goes back to, to Prof. Rule 39, 2D says, a lawyer shall not engage or be involved in any advertising or promotion of his practice of the law, which includes statements about the quality of the lawyer's work, the size or the success of his practice, or his success rate. Now, the interpretation of that, using the literal rule, is that it's outrightly prohibited to be involved in any promotion of his practice, which includes statement about the quality of his work. In other words, if I say, oh, this is what I do, does that affect, clients? And we're looking at competition now. Anyway, we'll come back to that because I need to bring up the point of law itself being a business, right? But at this point, are we looking at it as restrictive or permissive or totally, prohibitive? Because Section 39.2D, Rule 39.2D does not give any leeway. It says,
I don't know how you're reading it. It's simple. 39.2 gives a leeway. It is to look at the case studies of advertisement, and there are several. I do teach this now at one of the faculties where I have set up an ethics course as a pilot program, and you have sets of case studies on advertisement. You know how to advertise, and when you present those case studies, you see the difference between one that's ordinary advertisement and one that is talking about quality. They're very simple. Even our websites, I use websites of lawyers in Nigeria to interrogate which one conforms to these rules and which one does not conform. And they're clear. There are some that maybe some have middle course. There's nothing there's nothing bad about putting up a signboard in a newspaper as an advertisement, for example. Now, it is what you see inside now will determine how much of these rules you have infringed. So quality, yes, if you do, that's what the rule says, and so you can still achieve advertisement without attacking quality, without touching about quality.
Thank you, Prof. Clearly, that sounds to me like it's subjective, because who determines at this point whether it has infracted the rules?
The tribunal, the tribunal that will try you. Simple.
What tribunal, sir? Could you clarify?
Legal Practitioners Disciplinary Committee.
Wow. So there has to be, we're trying to put a situation forward that a lawyer that's just come out of school, who doesn't know what to do exactly, does he engage in these things until he's cited, or until he becomes...
Those are the same things as the other rules. The other rules are there waiting for you. There is no difference between one rule and the other. They're all waiting for you. The problem with advertisement has not been the law school lesson. The problem has been with you lawyers in the country. The young chaps come out from the law school and they learn that you can advertise, learn the limits. Even if it is they don't some of don't and others to do. And I've seen quite some number of advertisements by young lawyers that qualify for proper advertisement under 209. I've also seen ones that don't qualify. And some of them have called and said, using this rule, do you think this portion of this advertisement is okay? So they go and change it. So what we have is that when they come out, because majority of the old lawyers have not read the rules, they have never seen this rule in their lifetime. So they just quickly say, no, there's no advertisement. And they intimidate all the young people around them. They say, no advertisement, no advertisement. So the young people are trembling. There's a distinction between how to advertise and not show quality, state quality. The rules are there waiting for everybody. So one of the things, which is one good thing you are doing now, is that you are presenting this as a learning platform so people can learn it. You are not going to have the time to now do real case studies to train people on what is qualified or not. That you can set out in another forum. This is a sensitization program which you have done, which is very good. The next program you do, you create small lessons for us to do real case studies so that people can test it using real life advertisement right now existing. I have 1 million of them from you guys. So that would be a way to do the training going forward, because people have not really been trained. So majority of lawyers intimidate every other person around. No, well, there's no advertisement, and people are hiding under their tables when we're doing business.
All right, thank you, Prof. I recall I noted quietly that when you were giving an example earlier, you mentioned that some lawyers go to the radio and talk about, could go to the radio, that advertisement envisaged people that could go to the radio and speak, and that was what it was planning. It was intended
to, yes.
Yes, intended to forestall. Interestingly, technological advancements have gone beyond radio and all of that. And clearly, this when the initial RPC was put in place, we could never have imagined this sort of webinar coming up, because this is technology. And right behind you, Prof, I'm seeing that you're speaking. Right behind you, there's a banner, right, of your law firm. This could never happen when the RPC started. So you're muted. You're muted.
Can't you see I'm advertising without the quality, without talking about the quality of my firm, of my work? Clear advertisement.
So with that, I would like us to examine and interrogate how technology has really, impacted this Rule 39 practice of law. Has it enhanced it? Has it restricted it? And how is it possible to actually use technology for your own benefit without infracting the rules? Let me invite the Fernandez. Please, quickly.
Well, thank you very much for, I'm very happy to be speaking here. The first thing I want to say is that just like Prof has said, the rules do not ban advertising. Now, what it does, it says, don't do this, don't do this, do this, do this. But my interpretation, and I'm hoping Prof will agree with me, is that when you start looking at from 40, 41, 42, when they say in this kind of situation, you can do an article and put your name, you can do this. Those are indicative of some of the things you can do, but it's not exhaustive. So there's a lot more that you can do. Now, obviously, by the time the RPC 2007 was enacted, I'd say enacted, but that's a proper word. When it was enacted, we weren't expecting to be doing stuff on the internet the way we were. We were looking at it from the point of view of law offices. I'd hoped that the last amendment, the 2023 amendment, would have some input as to this advertising because it was a topical issue. Unfortunately, it did not. I can't say what the reasons were, but yes, the fact that the technology has changed sort of the way advertisement is done, or the way but in the core, it actually hasn't changed too much in the sense that the things that you're not allowed to do offline, you can't do them online. The fact that the RPC did not mention LinkedIn and did not mention Facebook and Twitter and all the other places does not mean that you should go and do those things that you are not supposed to do physically online. So, for example, somebody mentioned, Prof mentioned law firms where people go on your website and post stuff. Yes, your website is a virtual office. where people ideally, because your website is not somewhere you see on the street, it's somewhere people usually will type your URL or search for a certain thing and then go specifically to you. So obviously it should contain certain information about you. But when it goes on to talk about, for example, the size of your success, as Prof has stressed about, or it publishes your face alongside the cases that you've done, which is something that 39.2, I think, is that 39.2? So 39.3 talks about publishing your face alongside cases that you've handled. When it goes on to do that, or when it goes on to, for example, I know there's something that we do now. So it's not in the website. When you look at the website itself, you don't see it. But in the website metadata, when you're looking, you see top lawyer, top law firm in Nigeria. So you open the website and you don't see it. But when you're searching for it, you see it. And then you do that, you are in violation as of this moment. And I know that much has been said about what's happening in the US and in the UK. But for now, until our rules change, you cannot go and tell somebody you're the best lawyer, even though any other person. Of course, there's nothing saying that you can't publish, for example, let's say IFLR says you are a top lawyer in a particular category or you win an award. There's nothing saying you can't publish that on the internet. But to go on the internet and have a metadata that says you are the best in whatever, indicates clearly it's a violation of the RPC. Some of the very clear cases is the ones we do on our statistics, and I'm relatively young compared to the other panelists. So I can talk. I have a lot of friends who are younger, who, for example, you open their status and they're telling them, come and meet me, I will do this. Come and meet me, I will do that. Or I'm into this, I'm into that. Not just I'm into that, but sort of meet me, essentially, inviting, soliciting the public for support. There are also people who, for example, who would say on the internet, on their LinkedIn, I'm the best I'm the best blockchain lawyer, or I have 100% success rate in courts, or some of them, they're having a conversation and then they say, send me a DM, or you post a publication. Those are some of the very clear, almost instantaneous. You see it, I know that this person is violating. I think that Mr. Omole wants to ask a
Yeah,
question.
let
So
me
let me
take you quickly. Let me take you up on that quickly.
yes.
When you're talking about social media
Yes.
influencers,
Yes.
or a lawyer, you happen to be a lawyer, you do
Yes.
realize today there are actually law firms entirely online. I mean,
Yes.
when the IPC was conceptualized, I
Yes.
imagine it was brick and mortar. It was, you had to go into the four walls, into the doors of an office, to go into an office, to go into a law firm, right? But today
Yeah.
you have virtual law offices and they actually render legal services. So
Yeah.
at what point do you draw the line, right? That, oh, send me a DM. What does that mean? And is that, oh, send me a DM, is that soliciting? Or at what point do they begin to put out who they are? If this is what they do, how do they put out what they do
This is off
without
record.
infracting the law? How do they exist as a virtual law firm? Or how do you conduct your services? Even if you're not a virtual law firm, we're having a virtual webinar right now, right?
Yes.
You are
Yes.
sharing knowledge. We're sharing knowledge. Assuming you're
Yes.
a law firm and you're sharing knowledge and you're saying, oh, contact us for ABC. Is that soliciting? Is that advertisement? And is that advertisement, exaggerated? What are because we need to know the limits of technology. There is a blurring, quite all right? There is a blurring of, the conventional and technology enhanced, right? But we need to know where the fine lines are and tease them out. That's
Okay,
what
so my response to that, recall I had said that a majority of the things that you can't do offline, you can't do online. So if you write an article, for example, or in newspaper, and you say contact me in that newspaper, I say contact me for so and so, would you be in violation of the RPC? If you can't be in violation of the RPC, then you're in violation of the RPC whether you do it on the internet or not. Now it's a different conversation where you're having a conversation with somebody and you have sort of a bit of banter to and fro, and you already have, and it's okay, let's take this conversation offline. In that case, you're not, because you've had a conversation, but you're putting out something to the public and inviting the public and saying, everybody, you come and hire me. I'm the lawyer that does this, particularly in the wording. So, Prof had indicated that it's not so much the thing it's not so much putting out stuff that is the problem, it's what you put out. So if you are putting out and inviting, saying, for example, my law firm, I have a law firm in this, I am the best lawyer in this, please call me on 000 blah, 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 to do your legal, to all your legal issues, including blah, blah, blah. Obviously, that would be a violation of the RPC. But for example, you organize a webinar or you do an article on a particular area of law, and then at the end you indicate at the bottom that this article is no substitute for sound legal advice. Please contact your lawyer for so. I mean, that's entire thing is a publication. You have advertised yourself. You have shown that I'm competent in this area and I can give an opinion in this area. And then from time to time, of course, they say you're allowed to leave your name and a bunch of other things as required by the RPC. But in that case, you have expressed your expertise. So of course, you have your name. They can go to your website. They can go wherever they need to do and see your email address and see whatever address and find you. Of course, those things are available. And, sort of like I said, those are virtual addresses that are there. But for you to now go beyond and start advertising and requesting the other ones, I mean, that's where I think the line is drawn. But again, while it appears that I know a lot about technology, I may not necessarily be the expert compared to Prof, who are the ones that drafted the rules, and they say, Danny will tell us why this one does not follow. But my impression from the use, I mean, and for several years, we've been advocating for how to use technology for advertisement, firm branding, etc., without violating the RPC. And I agree that there are a lot of ways. Again, like put out your expertise, you can do webinars. There's nothing in the RPC that says you cannot advertise the publication you made. So for example, you do a publication, you want to release a book, you have an event, you are inviting people to attend. There's nothing that says you can't advertise your event. There's nothing that says you can't advertise your webinar. Those things are mediums or media rather of advertising, and there are lots of them. Putting out articles, having conversations about certain areas, those things are clear advertisements, but those are not banned by the RPC. But going ahead to do the direct soliciting, either directly or, and in the case of, I mean, there's a particular case that I think was referenced earlier, maybe in the previous conversation or here, about getting social media influencers to advertise, to do adverts for your firm. And then the RPC in Rule 39 rather, says, and I want to read that, Rule 39.3, it says, so that I'm not talking, notwithstanding the provisions of paragraph 1 of this rule, a lawyer shall not solicit professional employment either directly or indirectly by circulars, handbills, advertisements, through touts, or by personal communication or interview. Again, they said the leading parties either directly or indirectly through circulars, handbills, advertisements, through touts, or by personal communication or interview. So first of all, the idea of soliciting through, whether you're using a social media influencer, you are communicating, whether you are the lawyer doing it directly or you are doing it through another person who is communicating to the public. I mean, would you tell somebody physically to go and talk to, if he's a lawyer, say, Fernandez, go and talk to these people and tell them that they are giving me, that they should give me a brief? That would be advertising. So that would be advertising in violation of the RPC, but not, Prof.
Sure. I said sure.
Yes. But then, I mean, like Prof has said, and like I've continued to say, there are too many ways. There are too many. In fact, I think what the RPC did is it tried not to tell us all the things. It just said, don't do this one. But every other thing that is not there. So, for example, you open a LinkedIn profile, and LinkedIn profile requires you to put certain information. The RPC never anywhere says that you cannot put your biological or by the information on these places. You can put those ones, but as long as you don't go ahead to do those few things. For me, and I think that there are just a few things that you can just avoid and move around it. But you can have a LinkedIn profile that says something, as long as you're not advertising and saying, I'm the best lawyer, I'm a notorious lawyer, and I'm referring to what's this? 5 versus is it 5 versus what that matter, NBA, and a bunch of others. You can't do those ones, but you can do the more subtle, moving around, and that lots of law firms are doing it. Of course, I'm not saying you should do a video and say, tell us how your firm is and all that. Of course, that may be because they said you should not do sound recording for your this thing. So if you are recording a video, obviously there's a sound recording. But apart from that, you can do other things. You can do a video about an event.
Sure.
So you see,
you can do a video about human rights.
Yes.
Yeah. And put your name behind, just as I put my name here now. I'm advertising. Yes. All the things Doc has said are completely true. There's no distinction between the multimedia, the modern media outlets and the chalkboard and radio and all that. Just as he said, it is what is in it on it that is the issue. It's a different thing, Omole, if you are now asking that we should simplify the rules to make
that's where we're going. That's where we're going. We're
trying to. It's a different thing. If what
it's a different thing, but we're trying to provoke our thoughts.
Yeah.
See whether, because And that takes me to the next point.
Yeah.
Law being a business.
Yes.
Law being a business. We are, I mean, as lawyers, we're first and foremost businessmen, but called to a dignified call, right? And that's why clearly, I mean, our profession is one of nobility, right? But we have to still eat from what we do. Now, do you think, and this is to Prof now, do you think that the rules as it is now is restrictive in any way, restricts clients from being able to choose, right? The kind of lawyers they want? Do you think the leeway allowed by advertising now allows clients enough choice to select the kind of lawyers they want, one? And do you think that lawyers, especially new lawyers, do not feel disadvantaged, right? Or strung out by senior lawyers who really, and more accomplished lawyers who really do not need much of their lives out, who do not need as against
They've been praising so many lawyers.
as against as against younger lawyers who are just trying to make their mark in the profession, such that the younger ones are strung out as against, the older ones who've been there for a while. And this is about feeding now. This is about making a mark. This is about putting their work out there. Do you think these rules, as it is now, safely, give a safeguard to the younger ones?
Sure. Look, I don't like those words like nobility and all that. I hate it. Pardon I hate those words. They don't exist for us. The law is a business, simple and short. Now, my focus on ethics is to deal with honesty, human honesty. We don't emphasize that, and we're emphasizing advertisement. Now, the real job is that the young ones, because they have been frightened, are not using their weapon, and they're supposed to be the people having the weapon to advertise themselves. But if you look at the old lawyers are the ones advertising. The ones you say they don't need it, they're the ones advertising and violating the rules. Look at their websites. If you pick up 10 websites right now, 8 have violated the rules. 8. Now, if I start punching them out now, and young lawyers are hiding under the table, and the means of advertisement is so cheap. It's very cheap. Now, based on the technology, it's very cheap. It's not expensive. You don't even need to pay anybody to construct a website. Only need to do it yourself and pay $20 and you get a website. So, but long lawyers are not, reaping from these opportunities. For me, the rules as we have it now will be simplified. It's not more should. It will. We're working on it. We're working on it. It will be simplified. These rules, as I said, were made in 2007, and it was a copy of rules of 1974. So they are now 50 years old. I can mention to Doc why we didn't amend the 2007 rules in the 2023 rules. We didn't intend to touch the RPC because we only wanted to include the guideline on money laundering. I really want to quarrel with the former Attorney General, who we have quarreled with over his own personal amendment of our rules. So instead of going to that war, because we're in court with him, we decided not to touch the mainstream rules, just add our chapter 2. Then that was when we started working on the draft rule, which we are working on now. And therefore, at this time now, you have really created an impetus for a more serious work on it. I'm sure the president of the bar will soon probably announce a draft rule for people to discuss and before we move it forward. But if I knew half of the things I know now, the 2007 rules would be very, very simple. Would have been even advertising in the clouds, in the sky. I'm pro advertisement completely.
Okay. Yes. I was going to mention that under the current rules, this is advocating for the future. Now, under the current rules, it appears that the idea is to make clients to be able to go to all lawyers to provide an even playing ground. Right, but when you look at it, a client has it. We consistently tell clients to look for lawyers that are competent in specific areas. Because if you, for example, you go to somebody who has no experience with criminal, say for example, criminal matters, and they have a matter that involves death penalty, capital law, and then the guy fumbles your case, or so we consistently tell. And then if we are asking um, if we ask our lawyers not to indicate cases that they've handled, especially of course where you're putting your face. And I'm quite careful because that rule, sub rule 5, I think, says as similar. So sub rule E says as similar self-aggrandizement. So I mean that's an open-ended thing. So of course, because of that, people can be quite careful as to what you can put. And so if people are not able to put out information as to their competence, as to especially history matters that I've done. I'm even worried about putting things in my CV, to be honest. But if you're not able to do that, how are clients able to look at our work and pick and say, okay, this is the lawyer for the job, rather than go to any lawyer? And I know that there's an obligation on a lawyer to say, if you're not competent in this practice, you should work with someone else who is competent in that practice. And I know that that obligation is there. But what if the lawyer does not know? Sorry, the client does not know that, and then the lawyer does not do it, and then that's another matter. After the client's case has been fumbled, before you now start talking of whether or not if at all, you would even get to the lawyer to complain about that. So I think there is a need for us to look at that to see how we can. I know you mentioned that you're not averse to advertising, but that's the one area that I think that we may need to look at.
I agree with you. The thing is that's why I'm saying that when we streamline and simplify the rules, permit those things to be said, those quality things. But like the UK barristers rules now, give a guideline as to how to say it with evidence, and also create a strong capacity and more in our regulatory process, at least at the bar, where we may need advertisements to be cleared before we put it up. That and also people counseled on how to say things that are supposed to, because the people, in spite of the fact that we are hundreds of thousands of lawyers and 7,000 to 10,000 graduated every year in the last 2 years for the law school, the country still can't find lawyers when they need them. They don't know where to find them. That is reality. So it's helpful both we streamline and simplify the process of advertisement so lawyers can put up their work, because it's an access to justice issue for people to know when and how and who to look for, as you have said, to deal with particular competence issues.
Thank you.
But if we have monitoring system, advising system, approval systems, everybody, this will not be as opposite as we have it now, while many people are violating it. So many people are afraid of even saying their name.
Prof, you have just leapfrogged ahead of me, because I was literally going to this point of comparing Nigeria with the UK.
Yeah.
Because in the UK, okay, before I even do the comparison, it's like we're waiting for lawyers to infract the law and be cited for disciplinary action before knowing that, oh, I've gone this way. But I can tell you, most lawyers don't even want to infract the law. It's just that they don't know what to do. So we've got to we've looked at the UK. The UK says, oh, you can advertise. But there's a Solicitors Regulatory Authority. There's the Bar Standards Board for barristers. When you want to put out stuff, clear it with these people. You must get prior approval. Do we have anything like that in the NBA? No. So we need to start looking at that, because the truth is that most of the people on this, people that joined this webinar right now, there are people that are seeking guidance. They don't want to be on the wrong side of the rules. They're just people that want to know what to do, and there's that huge gap in showing them what to do. The only things we have are cases that have been decided by LPDC. Nobody wants to get there. It's not a pleasant place to be. So we're hoping that I mean, that's one of the things this webinar is doing. And that's what SLP does. Brings people, I mean, it was just that simple letter that triggered this thought. And the SLP said, you know what, let us give some light on this path. So we will be looking at pursuing this and ensuring, I mean, I'm sure Madam Chair, the chairman of the litigation committee will speak about that, to see how this can actually be seen through, so that less people are more educated at the beginning rather than rather than after they've gone into the hole. I think there was a case study shared earlier. I don't know if the polls are sort of ready. We're hoping that we can have some polls and have people speak to something, but otherwise we can just move on. Yeah, you wanted to say something?
Yes,
Yeah.
yes. So I mean, I meant to mention this earlier. So some of the things that we do, I mean, that we still cannot do with technology. So you cannot send out cold emails to all everybody in this thing, everybody's email address, and send them and say, "Come and work for me." Come and do that's obviously wrong. And there's something even more interesting. So we're on Twitter now. We're on social media. Everybody's there, and then somebody's having a conversation, and then you say, "Don't mind these fake lawyers." Don't mind these other lawyers. So yes, on the one hand, depending on the situation, it might be a violation of the RPC. But on the other hand, it may be a violation of the advertising requirements. On the other hand, it may not. And I want to say this. So we obviously have a duty to ourselves as lawyers to be candid, to be fair, etc. That's on the one part. But in respect of advertising, somebody might make you, so you don't want to put out a post that indicates that lawyers are bad, or that any other professional is bad, or that people are not doing their work well, or that, stuff like that, especially when you are doing it for the purpose of advertising yourself. In the sense that you are indicating, you are saying, I'm a good lawyer, these other people are bad, or these other professionals are not so good, and this is me. So in that case, if you're doing any sort of statement, whether it's on Twitter, whether it's a single tweet that you say, all these quack lawyers, I believe all these quack lawyers, I don't know what they do with quack lawyers, or something of the nature, and you post it out there, that would be a clear violation. But an instance, for example, I think that may not necessarily be is a lawyer has done something really bad, and I come out and I make a concern and then indicate a concern about the lawyer's actions being not of the standards required of a lawyer. I've said something bad about a lawyer, but on the other hand, I'm not doing it for the purpose of aggrandizement. I'm not selling myself. I'm not in the context showing any intention to advertise, but I'm making a comment. So I just wanted to be clear, because the rules clearly said you should not compare, you should not say anything that brings disrepute, etc. But then I just want to make it clear that it's not in all situations that will be a violation of the rule about advertising. It's just, you have to find a way to walk the tightrope so that you're not violating. Thank you.
Okay. Thank you. I think some questions have started to come in. We can start treating them right away. There's Cyril Ojionu who's asking whether we can resolve the concept of there being a virtual law firm, and says that it is now a reality. Has the concept of RPC really come to grip with the concept of the Internet of Things, which is now the world in Nigeria struggling to enter, but which the developed world appear to have embraced already. Fernandez, you want to speak to that Internet of Things, whether the RPC has come to grip with the virtual law firm concept and Internet of Things. Of course, let me add AI. Let me add
okay.
AI.
Okay. So obviously, it has not. And it couldn't have. It was written in 2007. So in 2007, I could not. I think I was using Microsoft Word at the time. But at that time, we used to have that small pin. When we talked about AI, we used to have that small pin that would just come front and respond to your comments. But that's about all that we knew about AI. So obviously, he has not. At the same, but that does not stop you from. There's nothing in the RPC that indicates that you cannot have virtual websites. However, that's a different topic altogether. Virtual offices. There's a different topic as to whether calling at a client's office for meetings, and that's an entirely different matter. Because in that case, if you are not calling at a client's office, the client has to come to your office. And where is your office? So maybe perhaps email communication. In which case, when does it start? When does it end? Etc. But yes, there's nothing in the RPC that says you can't have, properly speaking, a virtual office. But of course, in Nigeria, as with everywhere in the world, you have to have a physical address where communications can be sent physically. You have to have addresses for service, amongst other things. You have to be registered and all that. But as per virtual offices, obviously, you can have them. In my view, your website is a virtual office. Your Twitter handle is a virtual office. The Twitter handle of the law firm is a virtual office. The LinkedIn account is a part of your virtual office, and all these other handles, they are actually part of that virtual office. So whatever it is you're doing, you're allowed to do with your office. I think legally you are allowed to do. I mean, lawfully you're allowed to do that with those virtual offices. Of course, provided they're not in some cases where you're overdoing it all the time. That is making what's the word now? It becomes annoying. What's the word? It becomes a nuisance. I've forgotten the word that is used. It is, and you're not doing paid advert and pushing it on what do you call it, Google. And I've seen a law firm that did that. They are doing a paid advert for their law firm and putting it on Google so that anybody that goes to Google to search for anything is seeing them. So those things obviously they are somewhat of a violation. I mean, again, people can argue that way, but I think they are. But yes, you have a law firm. There's nothing stopping you from having a law firm and going through the lawful means of advertising those law firms virtually. But as to other registration requirements, obviously you need to have a physical address, you need to have address for service, you need to have all the other things that make you qualify to have a law firm. And as lawyers, we're actually supposed to give notice of our addresses to the law, to the branch of the bar that we're practicing.
Okay. Thank you. Taramasia Sami says that, I mean, it's a similar question, really. And says, what key guidelines must lawyers follow to ensure compliance for virtual law practice? I really don't think that is something we've discussed that now. There are no guidelines. I believe with time we will come up with, there will be guidelines from what Prof is saying that there will be. You want to say something?
Yes, I'm so sorry. So during our conversation prior to this meeting, I think I mentioned that to you.
Yes.
That's what I think we should do. I mean, both the litigation committee and the technology committee of the SLP is to sort of do an interpretative work on this and then put out some document that to some extent indicates the law as it is now. Sort of tries to explain it because it's a bit complicated when you look at it. You have to spend. I had to do a review before this meeting, and I spent quite a bit of time, trying to re-understand. Even though I've done extensive work on advertising for law firms, I still had to come back and So yes, we need to do some work that sort of explains those things and give scenarios and explanations so that people understand, lawyers understand things that we can share to complement what Prof and the people in law school are currently doing. So we're going to do that subject to approval by the appropriate authorities.
Yes, the use of the word extensive work for law firms is advertising, by the way. So I'm kidding. Just kidding. So
well, I'm talking to lawyers, so I'm talking to lawyers.
Just kidding. So somebody says you would like to be a part of the committee that work on the review of the rules. Of course, join the SLP first, and then we'll start to look at that. Somebody's asking if US and EU have similar rules and how they've embraced an emerging rule of virtual practice. Of course, all of that is going to be put into consideration in the rules that are being revised. There is a live poll that's been circulated. It's at menti.com. If you look at 1654, just about 8 minutes ago, 6 minutes ago or 9 minutes ago now, yeah, it's been shared, menti.com. You can go there and participate in the poll. Would like to have your views on that case scenario. Mr. Krukrubos says, or rather quotes Professor Ojukwu. I like that quote. The law is a business, simple and short. I am pro advertisement completely. People need to know how and who to look for when they need competent lawyers. We should frame that. So the poll is up and it's going to be running now. Inter Iguanam asks, how can a lawyer advertise within the bounds of the law without violating the provisions of the RPC? I need illustrations and examples to buttress this. Do you want to give one, or should I leave?
I was going to say the doctor should, because I don't think she's spoken. I think we've left her out.
So Dr. Hamid,
Hamid.
there are two things. One, two questions to you now. One, somebody needs illustration and example of what would violate Rule 39, right? And then Toyoko Krubo would like to know, SAN I should add, would like to know what law students should know about Rule 39 on being called to the bar. Not to pass the exam, but on being called to the bar. Dr.
Right,
Hamid.
thank you. Thank you. On an illustration that would lead to a violation of Rule 39. So the rules are clear. Advertisement is out. However, they must be fair and proper. Although I have a little problem with the interpretation of fair and proper, I think it's relative. What is fair and proper to me may not be to somebody else. So take, for example, I see on LinkedIn, or I saw on LinkedIn, a certain law firm celebrating one of theirs, an alumni, alumnus, that he was elevated from the High Court to the Court of Appeal. And in my head, I just thought, okay, advertisement or not advertisement? Well, it may have come out honestly, but thinking about it, if a client has a matter in that judge's court, would he not almost naturally go to that law firm, knowing the pronouncement that law firm has made? So things that are as simple as that. But 39.2 tells you what you cannot do. Naturally, you don't mislead. You don't make inaccurate comments. You don't do things that will bring the profession into disrepute. Those things are clear. The snag is where we have, don't talk about your success rate. The law says don't talk about your success rate, but again, how do you come out there and advertise yourself? Because everybody knows that law is a business. We're not, like Prof said, he's not into the that it's a conservative it's a conservative profession, or things that are like that. It's a business. You're in it to make money. How do you put yourself out there? For advertisement, I think it's the ways you can. So you have you're allowed to use your business cards, your complimentary cards. You have details of yourself there. You have granted an interview, not necessarily alluding to the fact that these are the things that you do, but you're speaking to that interview. Put yourself out there as being a specialist in that area. On the next question, what should law students know? Yes, law students should know Rule 39. Like we said, the rules are the rules until they are changed. So it allows for advertisement as long as they are fair and proper, and they conform with 39.2 A to E. And then no soliciting of any kind, no soliciting. Naturally, the legal profession it puts itself up there. Soliciting, what does it mean? It means to beg. It means to beg. It would be unheard of for a lawyer going out. Of course, people will, indirectly. So you're going to sit at the office of a client hoping that he will give you work to do. It belittles our profession, but thinking about the economic climate, I'm sure there are people that will engage in those kind of practices. But generally, 39 says it all for what the law students should know about advertising and soliciting. Advertising, yes, you are allowed to advertise, but soliciting is a no-no.
Thank you very much. I have a quick question on that. You mentioned being able to distribute my cards. I was at an Owambe party. Owambe is a big Yoruba party, recently, and there was a musician that was singing. Would it have been okay for me to basically go out there and give people my cards, and in fact put it inside the takeaway packs, the goodie bags, or what they call it, I don't know, those things, just distribute the cards, put it inside it where people are getting the souvenirs. Would that have been okay as a lawyer? Because I can distribute my cards.
All right, so my question will be, what would be your intention by putting your cards into party packs for people that don't party? Obviously, you're trying to attract clientele to yourself, and
yes.
Going back to, it won't be fair and proper, and it will bring the profession to disrepute. You as a lawyer going out there and sharing your complimentary cards at the Owambe party will bring the profession to disrepute, according to 39.2.
Well, that is what people are saying. Soliciting is not a bad thing. What is how right now, what we have moved away. I mean, America, even the British people, the solicitors have moved away from those restrictive to be paying you rent. We solicit right now. We do. We are doing it, and even what the one you have just described. All our big lawyers that have done birthday, open birthday ceremonies or halls, one memorial, one program or the other, have put their cards and packs and given us as takeaways. Big takeaways. So it's being done. It's not even a speculation now. Omole, they're no more speculating. It's being done. So the only problem that I don't have when I do parties, my money is so small that I want to give the small group my drink before I go print card. It's expensive to also do that printing of card. If I have the money, I go print cards, put for takeaway, make it carry go to.
But you asked us not to do that.
Soliciting is not a bad thing. There's nothing wrong with it. That's what we are doing. You have to solicit.
But it's in the rules. It's there.
Yes, the rules ban it. I agree. It's wrong. No. I'm talking about. We're now talking about the future. There's nothing bad about it.
Sir, can you before Fernandez, can I quickly clarify something for the benefit of younger ones? Is there a clear line between soliciting and then touting? And how do we draw the line?
Soliciting, touting is true tout. Actually, it's true tout. I mean, if you use an agent to go find cases for you and you pay him, and that's the only thing. For example, the Americans have banned about soliciting now, that you should not pay an agent. That's all. But whether you should start telling people, I'm here, go to the website of solicitors in England, go to all the websites in the US. The first major thing is they are speaking about their quality and their soliciting. They're telling you exactly what you should come and do. So the level now is to move away from all these old stories about barristers in England. We're not from England. We're not barristers. And remember, in England, that history, barristers took their own jobs only from solicitors generally. So they had a limited market. Here, all of us are going to Dubai, Wuse market, area to look for clients. It's not the same thing as those barristers who came from noble families and had ranches and already sources of income, and just go to court to do McAntony speeches and go home. Here, it's not the same thing. Where now all of us are heading to pay our NEPA bill in grade A, whatever they call it.
Band A.
Band A.
Prof. I was going to say this, and I think that's what the situation you have mentioned is sort of an idealistic situation where with an amendment of the RPC and other relevant rules, we'll get there. But until that time, I don't know whether it's 1 month, 2 months, 1 year, 2 years, 3 years, whatever that period of time is, till that time, we're still bound by these rules. And so for me, I'm quite careful about what I can do. So I don't know that I can share I can give my cards out, but not in the nature that would be so obstructive and all those things. And I will try to put that. But for now, what we can do, what I think, and I was going to mention, I'm doing like Donald Trump. But for now, what I can do is, so for example, I can write articles and I can publish them on LinkedIn. I can publish them on various fora. I can do events. I can publicize those events. I can do whatever it is I want to do with those events. Where I have what other things again? Yes, we can engage. There are certain conversations you can speak at events like this, and people are getting to know you, and then you can advertise those speaking engagements. You can post things on newspapers, not advertising your company, but you can say certain things. You can sponsor certain events and have your firm's name as the sponsor. You can, on the internet, you can of course, your law firm's website, and then you can put up articles consistently on your website so that it's ranking much higher than others in a particular area. So when they're looking for that authority in that area on the internet, you are the first person that can be reached. You can indicate, for example, your practice areas on your LinkedIn profile, on all those other professional, including Twitter. the kind of work you do, not saying the size of your success, not saying I'm this, but just indicating professionally what you do. You can engage in conversations. People are talking about things on the Twitter. You can engage in those conversations, and you know. But when it comes to your area, you are talking about it. You are putting short tweets. You are saying, no, I don't think this is correct. I think this is the position of the law as regards this. I think this is this thing, or maybe just join these conversations. And there are a whole lot of them. There are a whole lot. They're not limited to the ones I've mentioned, to be honest. You have an event like this, like has been mentioned. You have an event. Your member is being appointed something. There's nothing stopping you. You can do an end of year event in your this thing and talk about it. Those are subtle but clear means of advertising. No, you can join, do activities. So, for example, the drafting of the RPC, the latest version of the RPC, for example, that Prof is, and I'm interested in actually doing that work, and I expect Prof to call me immediately after that so that we can go and work on it. But you can join this thing, and then you can make comments about the work that you've done in those professional capacities, which obviously express your competence in that area, and a bunch of that. Just let's not be limited to the advertising. Of course, I'm hoping that will amend to allow a whole lot of the other things. But for now, maybe because I'm a small boy and I don't have as much experience, and I'm quite careful as to what exactly I can do so that I don't violate and go beyond. Because by the time, for example, I want to apply for silk, and they will say, no, you have been advertising, therefore you're in violation of the RPC and you can't become senior advocate.
Well,
It is.
And you're asking Prof for work, asking Prof to join the committee.
Yes, there are 3 questions, but let's just take a quick pause to take a poll, to look at the poll. Can that be projected right away? But while that is being done, let me read out a very important question while that is being projected. What about the law firm? Damilola wants to know, Damilola Wusoya. What about a law firm that publish their just concluded transactions on social media? Will this not be classified as advertising? I mean, clearly that has been answered. I believe Damilola understands that now. But does anybody want to just clarify that? That just concluded transactions. And but there's a more interesting question. Can a lawyer write an unsolicited proposal to a potential client? Unsolicited.
That's solicitation now.
Yes.
That's
Clearly.
Yeah.
Clearly. So I remember that even when I have to write proposals to firms that we've had a conversation where I have to specifically indicate, especially in the email, for example, as following our previous conversation or blah, 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 blah. So this is clear that we've had the conversation before I'm sending you. The client has requested a proposal before I'm sending it to him, as opposed to just sending it out to third parties.
So Obi Anoye, your answer is there. Can you write an unsolicited proposal to a potential client? That itself, though, you need to be. I think it depends on the content of the proposal. If somebody knows, for instance, that there's a company that wants to set up some sort of business and knows that they will require legal advice, right? What stops a lawyer? Is there anything in the RPC, in Rule 39, that says a lawyer can't just write and say, this is who we are?
That's Rule 39.3 now. That's solicitation.
This is what done.
Yeah, that's simply solicitation. 39.3. He says you can't do it.
So, Obi Anoye, unsolicited proposal. So you have to wait till your call, till there's an opportunity to speak with the person. And that's it.
If you like,
I want to ask.
If you like, you go to the person's church and wait for him to introduce yourself now. And the discussion can start, or the club, or his club, and the discussion can start from there.
So before we come to Japhet's joke.
So there's also so I want us to clarify that the rule on advertising and promotion is not just restricted to 39. I think it goes all the way to 47.
Yep.
All the way down to 40.
Yeah, specific ones, yes.
Specific ones. So, for example, 47.821 says a lawyer shall not search land registries or other registries for defects with a view to employment or litigation. So it's not employment for litigation. So you're going to registry, you say, these people have problem. Let me go and meet them and get, seek out claimants in respect of personal injuries or any other cause of action due to being employed by the prospective client. So I think this specifically talks about this particular issue where you know that this person already has this thing, you go and look out for them and then start going ahead. So that one is even clearly by the rules prohibited.
This is the point many people are making, that, look, there is a disadvantage for lawyers because other professions can say, hey, I see you're having... This is not champati now, but when you know somebody might require a service, they're wondering why you can't offer that service and be proactive. But the answer here is no, you have to wait. That's what the answer is.
I can tell you how I can tell you how I would do it, and I hope Prof will not say I'm violating it. I'm violating the rules. I would be friends with you. We're having a conversation. Of course, I'm just friends. You know, I'm a lawyer, so at some point you can come to me and ask me, "Oh, yes, it's true. What's your opinion on this?" I sorted the problem out.
Yeah, the problem, the major reason, why the rules of solicitation seem to be at least partly necessary is because of the value to be placed on your services.
Yeah.
The more likelihood is that if you solicit a job, your value will be diminished. More likely, you will have a strong bargaining power over the price, as different from they come to you.
Besides that, it brings down, it diminishes the reputation.
To an extent, yeah, because the same reason why they say we shouldn't go to somebody's house, even though almost all of us go to people's house. The reason, because if you sit down there, you know how you treat people when they come to you, how they spend 2 minutes before they enter, or 1 minute or more. The same way they treat you that way, and the man is upstairs saying, wait, and keep you in the parlor there waiting. So it's surely your bargaining power is diminished. That is more likely than not. But it's not a completely 100% regime anyway, but it has effect on your bargaining power to go for the job instead of them going for you. But like Doctor said, that's why everybody's encouraged to network, to join clubs, join churches and other social places, so that you can put that yourself there, and there'll be a platform for people to engage in discussion, which may lead to you making these proposals, as different from just walking up to the person and say, please, I'm a lawyer, I get people from all the houses where don't you come to me, and that's different. So it's like we found ways of doing the same solicitation, but in what we call the more respectable ways of doing it. Yeah.
Right. The poll says most people do not, most respondents so far do not think that Osasu's conduct offended the rule against improper attraction of business as contained in the RPC. If I may send a quick reminder, what Osasu did was to write autobiography. And he shared, and it was on the basis of that, basically chronicling his misfortunes, how his father was killed, because of an incompetent lawyer, right, who didn't point out an objection, who basically did not shoot down a confessional statement that was obtained by coercion. And basically, he was struggling when he came out, and then ultimately he became a lawyer. And despite having aced all his grades and everything, he still struggled to get clients. And then he did his autobiography and circulated. And the question was, do you think that was inappropriate? Most people think no. The jury is still out. What do you think about the current restrictive advertising regime? These are tools that we use in the SLP. I can tell you that this wasn't accurate because we didn't want to use Menti, but technology at this point, this was a quick stopgap. But the question is, what do you think about the current restrictive advertising regime? Should it be free for all, whatever? Nobody says it's adequate. Everybody agrees that it's not adequate.
Mr. Amole, I think the question just started, so we should give it a bit of time so that people will aggregate before we display it.
Right.
This particular poll just started.
Right. Okay. So
all right. So let me also mention the area of trial publicity. So you don't particularly put that in the realm of advertisement. Somebody telling you what has gone on in court and how he has defended his client, is more or less selling himself. So that's one thing that people seem to forget when we talk about advertisement, because I believe it's a subtle way of advertising as well. Just to add that.
Yeah, and it's permitted.
It's permitted. I think it's permitted.
Yeah, our rules permit trial publicity.
No, post. I would say post. Is it post trial publicity?
Well,
no. So the matter is still going on.
Well, sure. We headed it trial publicity, and it's permitted. That's the heading. He only tells you the things you shouldn't say.
Yes.
Well, he says
so
that.
I always hear lawyers condemning people coming out to face the camera. I say, you have not read the rules. If you read the rules, you won't be quarreling with people because you are shy of camera. You don't want every other person to be shy of camera.
Are you allowed to do trial publicity? Are you allowed?
It's right
the matter is still going on. The matter is still going on.
It's right there in our rules, yes.
So yeah, it's managing the circumstances, not
that's
everything.
All. The rule says exactly what you shouldn't say. What's right there, as the case is going on, you come out and inform the public what you are doing. It's right there.
But the lawyers say it. They go ahead and say it. That's the point I'm making.
Yeah, sure. I mean, because that's the problem is that I alleged it before. The older lawyers violate the rules on advertisement. The younger ones are beaten into their houses not to even do the one that is valid, and because they have refused to use their own knowledge in that respect. So now that we are conversing, if we want to chase people who are violating it, we can start. But if we want to converse first and write new rules and begin afresh, then we can start. I'm for any of them. I know I'm not worried about any of them. I as much as possible try not to violate it as much as possible.
Thank you, Prof. Before I take the next two questions, I think we should be done with this particular poll now to know whether the current advertising. No. Please go back, because we need to know what it was.
Sorry, Mr. Amole, I just want to make the point. Rule 33 says, and I want to read it out. A lawyer or a law firm engaged in or associated with the prosecution or defense of a criminal matter or associated with a civil action shall not, while the litigation is anticipated or pending in the matter, make or participate in making any extrajudicial statement. Please note, first of all, the matter is anticipated or pending. Then secondly, we are talking about extrajudicial statements that is calculated to prejudice or interfere with, or is reasonably capable of prejudicing or interfering with fair trial. That's as long as you are not in that space. You are not, first of all, if it's not if it's a matter that is concluded, that one, there's nothing about it. You can go ahead. There's nothing stopping you, at least not this provision. Then if it's an anticipated matter, a matter that is pending, you must make sure that whatever it is you're saying is not going to affect or prejudice the judgment, or it will not be expected, reasonably capable of doing any of those two things. Once you've done those requirements, there's nothing saying you can't stand in front of this thing. But for me, I don't do it is in front of the camera, Sha. But I'm just saying that the rules currently do not say
it's our biggest lawyers that are on camera. You have to have money after the cameraman comes and goes. They don't come to you again because you didn't give them some lunch money after they leave. You think that people just walk away in the car and go. Even if you walk away in the car, you have to give them lunch money somewhere. Otherwise, they're not going to rush around you again for the next interview.
It appears, Prof, and that the real answer to that is one should tread with caution in granting interviews as regards any matters that are going on in court. I mean, it's different if one is rendering, an opinion somewhere, but it can actually be sub judice. It can actually go. But we're now going outside of the realm of.
No. It's advertisement. You're on the right. You're still on the right path.
You're still on advertising. It's still actually on the right path.
You're linking it with advertising.
Oh, it is advertisement.
It's publicity. Advertising and promotion of the practice.
Yeah.
That's why I said people don't pay attention. People don't pay attention in that regard.
Nigerians love the lawyers who appear on those post-court matters. They love them. They are the people that go to give more brief. So if you are not doing it, you are just shortchanging yourself.
Prof, I want to add that in doing that trial publicity, in that whatever it is we're doing, there's also the requirement for us to respect the court. You know what? Remember our responsibility to the court, responsibility to other lawyers. So when you're making comments that deride other lawyers or that draw down the integrity of the court, etc., those ones are clearly a violation, not advertising, but general violations. But as long as you are within that thin line, as Mr. Omole has said, carefully threading.
Yes, and the thin line is very simple. If you explain what you did, because your clients will be sitting down. I don't know if you have that experience. I have a ton of it. My clients are sitting down with me in court, and we are leaving. He didn't understand what happened. So some of those things help people, especially if there are matters that are in the public domain that people are interested in. They want to know what happened, what transpired, as different from giving opinion as to whether you are going to win or not. Those areas should be avoided. So it's helpful to the public to know what happened today. Why was there an adjournment? You apply for this and you oppose the defendant opposes it because of this, and the court adjourned for ruling. There's nothing wrong with it. But that your face is what is advertisement. It's important. But the rule says you shouldn't call your name. That's all. If you call your name,
I think proper guidance will have to be sought again on that topic, because it's a very thin line. Very thin line. This particular poll, should personal narratives or autobiographical accounts such as sues be permitted as part of legal advertising or strategies? Majority say yes, as long as narrative doesn't any ethical image. Others say no. The reason we're can we mute that person? The reason we are taking all of this is because we need to get whatever. Now, somebody also wants to know before we wrap, because we'll be rounding up very quickly, very shortly, while the next poll is on. Somebody gives a practical example here. He says, if in an estate meeting, a member discussed the possibility of engaging me for my legal service, can I do a follow-up with a written proposal to give him details of my services and areas that can benefit him? The answer is yes, because you have been approached. I don't know if any of the panelists wants to differ on that, but
no, you're correct. Yeah.
I mean, I already said it. You already had the previous conversation, so you can send the email. Yeah. Of course, to be safe, as discussed in following our conversation in the blah 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 blah.
So as it is now, and this is for Prof and the team that will be reviewing, do you believe that restrictions on advertising disproportionately affect new or less established lawyers? We spoke about this before in our Most of them think yes. It creates a barrier for emerging lawyers trying to establish their reputation and practice. Now, we're not imagining this. This is live. People are voting right now on this panel.
I don't agree.
So, yeah.
I don't agree. I disagree.
Yeah, panelists.
I disagree because if we say we should advertise, the bigger law firms have all the money. They will advertise more than you. They will outspend you. So it's not going to be any different. They will go to NTA. If you say everybody they'll go to NTA and they'll do all the billboards. How many billboards can you do?
No, but on the other hand, many big firms, even in America, do not advertise because they feel they are too big. So, and if you see the number of advertisements in America, the number is heavier at the bottom than at the top. The number of sole practitioners advertisement is more in America than big firms. So it depends on the environment, but at least there should be a room. Not the restriction. It's not the restriction that is the problem. Restriction is not the problem. The important thing is that people should have access. And now that we have our technology, the younger ones have no reason to complain about access if they're allowed to advertise.
Merit Divine wants to know, does client review or testimonial amount to soliciting which is a breach of the RPC?
Yes and no, not soliciting, but the quality, yes, it's not soliciting, but the other ones that talks about you getting people to be singing your praises and so on. There is a violation under our rules. No, but like in England and all that now, it's no more a violation. But you have to put the quotation of their client of what they say about you properly and name the person and name the source, so that it will be clear who said this thing about you.
So the answer to that would be yes. Sorry, that no, it's not a
violation. It's not that. It's not solicitation, but it's against it's against advertisement rules.
It just has to show, the basis and who is saying what.
No, right now, it will be against our rules because of the getting a third party to talk about you. It goes to quality and aggrandizement and so on and so forth.
Okay, so I think we've come to the end of the poll session, and also coincidentally, the question and answer. I think that's the last question. Just that Olaulo Soyin, who is an executive member of the SLP, is asking, instead of focusing on advertising, when the majority of lawyers provide virtually the same services, should we not emphasize lawyers to specialize more? Well, that is not for the it's not with the view of this subject, but you have a point there, Mr. Okoye. You have a point there that there should be more specialized, because the more people specialize, or the more people, then you can know, oh, this is what this person does. But there's still really nothing wrong in Nigeria about being a generalist, as you know.
Yeah, but I wanted to that people are forced to specialize. You don't even need counseling. As you grow in your legal practice, you will be forced into some tracks that where you're going to be constantly dealing with. So you abandon the rest. There are too many areas you cannot come in and I will tell you anything about. So I quickly call somebody else and tell and connect you. But if you have a big firm, what you do is to begin to get different units to develop more capacity. But surely you'll be forced out. I mean, by your own self, you'll be forced out by business to follow a few tracks other than others. Even your environment will force you. If you go to my village now to do a lawyer, you are going to be only land matter. Nothing else you can do. Land matter. That's all you can do. Nothing else you can do. So you become a specialist in it.
Right. So before as we round up now, let me ask, because I want to go back to the nature of the profession being, conservative, and I want to ask each of the panelists. Let me start from Fernandez. How do you think technology what do you think we can do better as members of the legal profession using technology to stay within the confines and then to keep the sobriety, I'd say, or the reverence intact within the legal profession using technology? Despite the technological disruption, should there be a shift or should there be a striking of balance?
Okay, so I think specifically that and this has been indicated, so maybe I'm beating a dead horse or something. But the point is that there is need for some shift, and I'm happy that the rules are being amended to that effect to make some change for it. But even within the confines of the present rules, I think there are a few things that we can do to maintain the dignity of our profession on the internet. So there have been indications of a committee, the LPDC or anything. I think it's something that the NBA can do to actually take steps to review the advertising. First of all, we can start by providing better standards, clearer standards. It has to be clear. People don't have to be doing is this or that, is this or that. We have to clarify and agree on that clarity. Once we do that, we can now go on to enforcing. How will do enforce? What do you want to do? And then we can set up a committee for review to take certain actions. But those are the two things that we need to do. We need to do a lot more in terms of education of what advertising is, and we need to specifically indicate to everybody that you can advertise. And I don't know, why we keep saying it, but we need to clarify that you can. But then consistently indicate what areas. Clarify that. Once we clarify that, we encourage people to do so, and then we punish those who. Again, what I will ideally do is to look for the big fishes. And once you punish the big fish, usually it has a trickle down effect. and then you come down. But you have to first do a job of clarifying, because for me, there's still a lot of things that you're not so sure of. And so people are just being extremely careful so that you don't step on some toes. So if you can clarify that, then you can take the next step to do that. I want to make a comment, sorry, back to the issue of trial advertising. And I'm almost done. Advertising, trial publicity.
30 seconds.
Yes, no, I'm already done. There's the issue of when matters are sub judice, certain comments I should not make when the matters are sub judice. It's important that you avoid those even while you're doing your trial publicity within the ambit of the RPC. So,
Thank you very much. Dr. Hamid,
Yes, please.
we've heard all of this, and what do you think in terms of preserving the culture, or I'll say the outlook of the legal profession in Nigeria, which is very revered? What do you think, the students need to know to better instill that, the traditional values, considering that, and I'm sorry to make allusion to this, we all know what is upon us now with the new generations coming up. I'm not the one that named them Alpha. I'm not the one that named them Z or whatever, or Beta that is coming. But clearly, the law school has quite a bit to do in letting people know that, look, yes, you're coming with a mentality, but you're going into a profession that is revered, that is hallowed. I mean, I want to know what the teachers are going to be doing about that.
Right. So the aspirants, the capacity we have is what we can do within the time frame that they're with us. So they come in and we emphasize these things, that are laws to them. Unfortunately, many of them are after, to learn it and to unlearn it, drop it in the bar examinations, and then so that they can move on with other things, But the thing is, like Prof alluded earlier, a lot of people don't even know the contents of the RPC. Last year I was called to, to a retreat where a law firm, we're going to merge with another law firm, and they wanted somebody to address them on ethics. And that was the first time in about 20 years I was called to anything like that. People don't remember the RPC. And I was saying things within the RPC, and people were looking at me strangely. Senior advocates of Nigeria, some of owners of, some of the top law firms. So it can't start and stop at the law school. We can't do all. Yes, we can pass the information on to them. We can teach them. We can tell them the importance of it. But it is what they do with it afterwards that matters. So they go out, they have become legal practitioners. They emulate what they see. What do the big law firms do? So we have said it time and over again, that they're the ones that are mostly in breach of these things. So whatever they see, they tend to copy. So we have a responsibility towards these people. The NBA, the body of benchers, that they are beginning to make moves now. So like yesterday, we had one of them come to address the students on the rules of professional conduct, which I thought was good. It was done again last year, but that's just once in a year. And how much does he want to do for anybody? So it's everybody has a stake in this. Everybody has it. So it doesn't start and stop at the law school. When they step out there, what do they see? What do they perceive? And that takes them a long way on what they're going to do with it.
Thank you so much. Clearly, there's only so much you can do once they're out of your walls and they have passed with distinction. There's not much you can do. Again, you can't retract or retrieve the certificates. And that's why I'm going to Prof last. What are we supposed to look at in terms of, I mean, we see all sorts now, the choice of words of younger lawyers, how they appear in court. Now, this is not advertising or whatever, but it's all encompassing, and the culture, how can it be better indoctrinated for practicing lawyers now, not people who have left law school? Prof, I'd like you to just throw some light on what can be done. I mean, I know you alluded to something before, which I totally was in sync with. I mean, there should be standards board. There should be something within the, that before disciplinary action, people should be called back, but can we hear something from you on that?
Yeah, the problem is much bigger than us. The law school can only do a rules-based training, a lesson for a couple of weeks. The ethics aspect can only last for a couple of weeks. That cannot create an ethical lawyer. That's just for the rules, to prepare them for the rules for practice. So the ethical aspect is only a rules-based learning. And rules-based learning does not create an ethical person. We have lost the opportunity and we'll continue to lose it unless we as the profession decide to tackle the problem. You have the university students spend 5 years between the ages 16 and 22 and the university at their most formative years, 16 to 22. The best time to readdress somebody's mental state and orientation. 5 years is the longest in the world. If direct examination without spending another course and coming to is the longest, one of the longest in the world. 5 years legal training, and we do not no ethics in training. And you wait for them to go to law school and spend less than 1 year, and out of it a few weeks on ethics. It's not possible. You are forcing on law school a burden that they cannot discharge. So we are not going to get any ethical lawyer based on what they learn at the law school on ethics. Surely, our teacher have said so. Now, if we want to begin to address this situation, we have to get back to our first year and all that 5 years program and begin to do the norms and the rules and substantive education on ethics. And I do not agree that the subject of advertisement is our problem. We do not have better. We are not better lawyers than American lawyers who are on billboards on the road every day. We're not better than them. And dressing, we should dress well. For me, those are advice I give to people. But we tend to focus too much on these technical things, dress well, advertisement, and so on. When the main problem, we are not tackling it. A culture of dishonesty in the country. We are dishonest people. And our lawyers are coming from this culture. And the average law student would tell you a lie at the first question. So, right now that we're using AI, the first thing they do is to go and give me answers from AI. And you ask them, they deny it. I said, well, I don't say you shouldn't give me an answer from AI, but admit it so that I can tell you how to use it so that you not hurt yourself and so on and so forth. So, issue of honesty and dishonesty, we have not placed it at the forefront of the profession. If we get honest professionals, these other things will fall into line on their own.
Thank you, Prof. I'm not sure how SLP is supposed to do that, but we will do our best to communicate this to people that need to. Because this is a very fat elephant in the room. The honesty thing and integrity, because the profession is one known for integrity. And unless we want to be self-destruct or implode, then lawyers should stick on the right path, because we're all ministers in the Temple of Justice. On that very note, I want to thank everyone that has participated in this. All the points taken here will be collated, including the polls, and we use all of these things in the SLP as as data for improved response and legislation and advisory or advocacy, as it were. And I'm happy the chair of the section is here. I'd like to thank particularly Professor Bayadere Legbe and the chairman of the Litigation Committee, who I'm calling on now, who I'm inviting to join, to basically say a word now. And then Fadekemi, who's been at the back end, and the remaining of the team, the rest of the team at the back end, throwing the polls, Daphne, Monica, and Abdurrahman. Thank you very much. Let me invite, and panelists, of course, I can't thank you. I think Mr. Kokrobo should do that.
Thank you.
I'm too small to thank them.
Thank you, Bayo. Great job, and to say special thanks to Leonard Brothers and Professor Ernest Ojukwu. Just to throw in a little trivia there, I contacted Prof on the 17th of January, at 8:35, and in less than 14 minutes, he got back confirming his willingness to be part of this, and for that, we're really truly thankful. I would also say, Prof, that the corrections you made while we were engaging, I have saved them and I've learned from them, because as a true teacher, you have consistently guided us. Really, really grateful, sir. To Dr. Hamid, brilliant views. We thank you for the great work you're doing in the Nigerian Law School. We know it cannot be easy. You have a constant flow of young ones coming in, year out. So your job cannot be easy. But we'll continue to ask you and those that you work with to put in your very best, because if the tertiary institutions do not get it right, I agree with most of what I've heard here. 1 year may not be sufficient, but at least it could ignite the beginning of something new and fresh. My brother and friend Fernandez, always a delight to listen to you, and the fresh perspectives that you've consistently thrown, not just in your work, the great work you're doing in your committee in the section of legal practice, but also on this platform. I'd like to say on behalf of the chair of section who has so graciously permitted us to do this, that this is a conversation that just has to continue. And I would be making representations that we have a more robust, much more robust discussion at the forthcoming conference later in the year. If I get the permission of the section chair, we definitely will have this topic being discussed, because from the questions I see, there's a lot that needs to be cleared up. I'd like to speak specifically, finally, to one of the questions. It's more like a comment from Susan, who essentially says she thought she was here to gain more insights, that if there are any insights you're yet to gain, please look out for other activities. As Prof and the other members of the panel have said, a lot of work is still being done in reviewing the extant rules to hopefully make it more simpler, so all of us have clarity as to how to move forward. So look out for more activities of the section on legal practice. And I want to really thank each and every one of you for being gracious enough to give of your time on this very important topic. Thank you once again, and God bless. Thank you.
Thank you.
And Omole should tell us the native doctor from Anambra that is treating him, because he's not looking that terrible anymore.
Well, I drank a lot of water. Let's leave it that way. Water is the solution to all life's problems. Thank you so much for everything. And Susan, everyone here, you're invited to join the SLP. If you still have questions, please reach out to us. We will answer them. Thank you. Yes, the recordings, I don't know. We'll talk to the Secretariat to make them available if possible. But thank you for staying till the end. On that note, it's a good night. Until the next session, God bless you all. Bye-bye.
Thank you. All right.
Thank you.
Thank you. Good night.